In 2022, the trucker convoy shut down Ottawa's core until the never-before-used Emergencies Act was invoked. 4 years on, and the federal government is still dealing with the legal fallout.
Today, the Federal Court of Appeal handed down a massive and historic victory for the rule of law and for the rights and freedoms of all Canadians.
The judges found while the harassment of residents and business owners was highly objectionable, it did not amount to serious violence or meet the definition of a national emergency.
The federal government has invoked the Emergencies Act.
That cleared the way for extraordinary powers, including the ability to freeze bank accounts. A public inquiry later found the decision was justified. The federal court and now the Court of Appeal ruled it was not.
We were convinced at the time, I was convinced at the time, it was the right thing to do.
Ottawa swiftly appealed in 2024, but on Friday lost again.
Public sentiment about the right of certain people to protest and the uncomfortable impact that has on those affected by protests isn't sufficient to invoke the Emergencies Act.
The decision marks the latest legal development in the convoy saga. Organizers Pat King and Tamara Leach were both found guilty of mischief. Chris Barber was also convicted. The Office of the Public Safety Minister says it's reviewing Friday's ruling and considering next steps.
A future government that might want to use the Emergencies Act is now going to be extra conscious of the fact that there will be judicial review in all probability if the government goes too far.
A pandemic-era protest shaping Canadian law in the present. Touria Izri, Global News, Montreal.